Hey everybody, welcome in. We'll give it about a minute or so to let people trickle in before we get started. Thanks for joining today. Okay, well, it looks like the participant number is plateauing, so I think we can get started. Welcome everyone to today's talk about navigating the ongoing migrant family separation crisis in the US. My name is Derek Lowe, and I work at the Acacia Center for Justice, where I'm the Director of Learning and Development. My work focuses on Acacia's Unaccompanied Children program, and that program provides legal services to immigrant youth in the custody of and released from the Federal Office of Refugee Resettlement. Prior to joining Acacia and its former organization, the Vera Institute of Justice, I was a removal defense attorney at Immigrant Defenders Law Center in Los Angeles, California. Today, I'm really happy that we're able to bring together leaders and advocates in immigration law, child advocacy, and border rights to explore far-reaching impacts of current immigration policies, particularly those that affect children and families. We hope to learn from practitioners who have firsthand experience working to address family separation and the challenges of family reunification. I hope today's conversation will delve into the legal, social, and policy aspects of this humanitarian crisis, focusing on practical solutions, the importance of collaboration, and the way forward in today's political climate. Some of you may be familiar with this idea of family separation. At first, got a lot of attention in the news during the Trump administration, and it was referred to frequently as the zero tolerance policy. But today we're still seeing family separation, and it's very much still an issue affecting migrants seeking protection in the United States. Before we get started with today's substantive conversation, just a few real quick housekeeping notes. We are recording today's webinar, and we'll share that recording with all attendees after. Due to time limitations, we won't be taking any live questions, but feel free to use the chat to share any important information that you have or any questions that maybe we can respond to after today's discussion. Any follow-up should be directed to Molly Chu, who's VECINA's the director of VECINA's Reunite project, and she's also the person who brought us all here together today. So thanks for that, Molly. And with that, I think we can start with some quick introductions. We're joined by an esteemed panel. First up, we have Marilia Richards, who's a managing attorney for Kind New York's Detained team. Before she joined Kind, Marilia was the senior immigration litigation counsel at an immigration firm in New York City. And there, her practice focused on a wide array of complex immigration matters, including family-based immigration, naturalization, asylum, removal defense, and special immigrant juvenile status. During law school, Marilia represented unaccompanied minors in their asylum and special immigrant juvenile status claims, and as a member of the Immigration Law and Litigation Clinic at New York Law School. She's been fighting for immigrants' rights for many years, both in immigration and housing law. She's from Bolivia originally and immigrated to the United States with her family when she was 6 years old. Marilia, thank you so much for joining us today. We're also joined by Juliana Pinto-McKean, who's a child advocate supervisor at the Young Center for Immigrants' Rights. She holds a Master's of Science in Social Work from Columbia University and a bachelor's degree in psychology with a minor in African American, Puerto Rican, and Latino studies from Hunter College. Her passion for serving the immigrant community comes from her own experience. Juliana was previously an undocumented immigrant herself. She's originally from Colombia, and she traveled with a family friend to reunite with her mother in the United States at the age of 8. Juliana, thank you so much for being with us today. We also have Nicole Elizabeth Ramos, who's the director of El Otro Lado's Border Rights Project, a program that provides legal orientation and accompaniment to asylum seekers at the US-Mexico border. El Otro Lado also conducts human rights monitoring, engages in advocacy before international human rights monitoring bodies, and spearheads federal litigation challenging border enforcement policies that restrict access to the U.S. asylum process at U.S. ports of entry. Additionally, Nicole also serves as a consultant for a multi-year community-based research study on the impact that restrictive border policies have on health outcomes of pregnant asylum seekers and their children. And she serves as an adjunct professor at Temple University Beasley School of Law, where she teaches classes on the border and movement lawyering. Nicole is a frequent lecturer at universities and law schools throughout the United States and Mexico regarding the impact of restricted border policies on the right to seek asylum. Our last panelist, who I mentioned at the top, is Molly Chu, the director of VECINA's Reunite project. VECINA is a national immigrant and refugee justice nonprofit. She's been working with recently arrived unaccompanied immigrant children and their families for over a decade, both in detained and post-release settings, including foster care, shelters, and she has also overseen the provision of post-release services. Now at VECINA's Reunite project, Molly spearheads the United States' only program that provides free legal services to the family members and other loved ones of detained immigrant children, with the goal of helping them secure the children's swift release from government custody to begin the journey towards healing together. Molly is a Department of Justice accredited representative. It's such a pleasure and honor to be with you all today. I look forward to leading us through this discussion and hearing directly from you all as you share your expertise and experiences. So with that, I think we should get started with some substantive questions. Madulia, first question is for you. We're going to talk a lot today about children who have been separated from their family at the border. Can you tell us which children this is happening to and why?
Sure. So thousands of children each year come to the United States from all over the world. Many of these children undertake the journey alone, either in search of safety, persecution, violence, abuse, or other threats to their lives and well-being, or to escape poverty, natural disasters, or reunify, right, with a family member. Some children may travel with parents, legal guardians, and then are separated from them either by US or other immigration authorities, or experience a parent's loss or disappearance during this perilous and lengthy journey. Other children may travel with a non-parent relative, a family member such as a sibling, a cousin, a grandparent, and then are identified as an unaccompanied child by operation of US law. So the legal definition, right, of what an unaccompanied child is comes from the Homeland Security Act of 2002, which establishes that an unaccompanied child is a child under 18 years old who has no legal immigration status in the United States and who does not have a parent or legal guardian in the US or who is available to provide care or physical custody. This determination is typically made by US Customs and Border Protection when the child first arrives at the border. So a child may have a parent or legal guardian in the United States, but it just is not physically with this parent or when the child, arrives at the border or encounters the border authorities. So additionally, the definition and several other specific safeguards created through the Trafficking Victims Protection Reauthorization Act of 2008, that's a mouthful, or TVPRA, are designated to protect children from trafficking and other harm. And prior to the TVPRA, children arriving at the border alone could be returned to Mexico or their country of origin without any protection screenings to evaluate whether they would face persecution, trafficking, or other harm if they were returned. So the TVPRA provisions ensure that the children will receive protection screenings and that they provide additional safeguards such as access to counsel, independent child advocates, exemptions from one-year asylum filing deadlines, an opportunity for a non-adversarial asylum interview to help the children fairly access any legal protections which they may be eligible for, focusing on whether the child arrives without a parent or a legal guardian. The legal definition recognizes the particular challenges that a child may experience if they are alone in the immigration system that is designed largely for adults. And it maintains the rights of parents regardless of their immigration status to be able to provide and make decisions on their child's case. So under this really, really long definition, a child who arrives with a non-parent family member, such as a sibling, a cousin, a grandparent, aunt, uncle, is still considered to be unaccompanied. the family member traveling with the child may be a trusted or safe, loving caregiver for the child who can potentially serve as a sponsor for them eventually. However, their relationship to the child will have to be further evaluated, consistent with these child welfare practices. The TVPRA's aim to safeguard children.
Great.
So.
Yeah, go ahead, Marily, go ahead. I mean,
I was just gonna say, the children who are determined to be unaccompanied by CBP are then transferred to the care and custody of the Office of Refugee Resettlement, or ORR, which we will be talking about a lot, which is then tasked with identifying a temporary care placement for the child while ORR works to identify and reunify the child with a safe and suitable sponsor.
great.
Go ahead.
When you say that they go to ORR, right? When they go to the Office of Refugee Resettlement, what exactly does that mean? What sort of, are they sent to a physical place? Is this sort of a virtual designation? What exactly is it?
So they do go to various shelters or facilities throughout the United States. There's about 280 facilities and programs. These include shelters, foster care placements, residential treatment centers, or other programs that provide care and custody of the unaccompanied child, pursuant to this TVPRA and other program requirements. ORR then has to identify a temporary placement that is the least restrictive setting in the child's best interest, while it works to reunify the child with a safe and suitable sponsor who will care for them during their immigration proceedings.
How long are they there for?
Yeah.
Yeah.
So the minors could be there depending on who they are going to reunify with. Priority is given to a bio parent. We've seen children who have been there approximately a month and reunified, and we've also seen children who have been there close to a year and are still waiting reunification with their adult, whoever this adult may be.
And do some of these children opt to maybe consider returning to their countries of origin, or are all of them, seeking to stay in the United States on a long-term basis?
That's very case by case. We have seen children, right, who have opted to return, and that's called voluntary departure. They ask the court to be granted this voluntary departure to just leave the United States. A lot of times is very dangerous, right? Because they're going back to the place that they were fleeing from. But that is one option that the child has. Sometimes they stay in ORR custody until their immigration proceedings are completed, until they have some sort of legal relief. Like I mentioned, if sometimes they're reunified within a month, and then they continue their immigration journey.
And if you could just flesh out a little bit more, what do these facilities look like? Are these jail-like settings? Are they foster homes? You mentioned that they can be a little bit different. Maybe you could provide for the audience a little bit more color on that point.
100%. A lot of times we say that a child is in a detention facility and immediately our minds go to jail, right? For the most part, these programs are not jail settings. They are the least restrictive, which means they could be shelters or foster care placements. Here in New York, we have facilities where the children are living with foster parents, and then they come to the facility during the day for like school. The goal is for them to be in the least restrictive setting possible. But
so the goal is for them to be in the least restrictive setting until they're released. While they're still remaining in that setting, can you just let us know a little bit, what does your work mean for children in custody? How do you work with them? And generally, your organization, KIND, Kids in Need of Defense, what sort of services does KIND provide to children in ORR custody?
So KIND's role is to provide Know Your Rights presentations in education, legal screenings, and eventually full legal representation in immigration proceedings for unaccompanied children. We work with children who are currently in detention in ORR custody, and then children who have also been released to from ORR custody into their adults within our specific geographical areas. We also help children, connect children with social services, healthcare, school enrollment, help them, access other support while after they've been released from the OR facilities. Sometimes while they are detained, my office, the detain team, right, here in New York, we also connect their potential sponsors with VECINA, who will then help and guide them during the sponsorship process.
Thanks, Manulia. I think that's a great segue. We've talked a lot about release, we've talked a lot about sponsors. There's this sort of constructive family separation nonetheless, even if it's not happening as explicitly and dramatically as it was during that zero tolerance policy time. We're still seeing children kept from their families and loved ones by the US government. Molly, I want to ask you, because I know you work really closely with a lot of the sponsors at VECINA, can you tell us a little bit more about what that process is like from the sponsors side of things, from their perspective, from the families seeking to be reunified with children who are in government custody?
Sure. Thanks so much, Derek and Marilia and everyone else who's here today. Happy to dive in a little bit more on the sponsorship process specifically and what this looks like from the angle of the sponsor. Before we do that, I think it's important to highlight a little bit of what is a sponsor, who is a sponsor, what does it mean to sponsor a child. The sponsor is a trusted adult who is responsible for caring for an unaccompanied child, receiving them into their home, and providing them with care for at least the duration of their legal proceedings, which, as Marilia mentioned, can be many years long. And so for the vast majority of unaccompanied children who are in ORR custody, these sponsors are actually blood relatives. About 90% of unaccompanied children have a relative in the United States who's eligible to receive them. For about 50% of these children, that relative is actually a biological parent. And so for most kids we're talking about who are in ORR custody, they are attempting to reunify with a family member here in the United States. In some other instances, they're unaccompanied children who maybe don't have a relative here in the US, or they don't have a relative who is able to receive them. And so they may consider reunifying with a family friend. That's something that we see in many of these cases too. Depending on how closely or how specifically the sponsor is related to the child, the sponsor may have more or fewer requirements and steps to complete in the sponsorship process before the child can be approved for release to their care. Some of these steps that they can undergo, depending on how they're related to the children, can include completing a pretty extensive sponsorship reunification application, undergoing extensive verbal interviews, submitting supporting documents like IDs, proof of address, birth certificates, in some instances, a letter of designation from the children's parents in home country, if that's applicable. For some sponsors, they have to submit fingerprints and have to undergo a pretty rigorous home study visit and inspection, or sometimes more than one home study visit and inspection. And depending on the type of sponsorship case we're looking at and who the sponsor is, it is also possible that many or all of these requirements will pertain not only to the sponsor, but to all of the adult household members who live in the sponsor's home as well, including things like fingerprinting and providing an ID. And as you can imagine, this might be very frightening to certain individuals, sponsor and household members included, particularly because so many sponsors of unaccompanied children are undocumented themselves, as are many of their household members. And so coming forward and putting themselves on the radar of the US government for this process can be particularly frightening, especially given that in years past and under previous administrations, some sponsors and or household members were actually apprehended as a result of coming forward and putting themselves on the government's radar as a part of this process. And so that fear, even if that is not a current practice, that fear is definitely lingering among many migrant communities. And so that's something that can oftentimes be a pretty serious barrier in the reunification process because so many sponsors are fearful of complying with these requirements. Among that challenge, there are many other barriers and challenges that sponsors often face in the reunification process. I could name hundreds of these that we run into, but just some of the more common ones that we see in working with sponsors. Many of them, unfortunately and sadly, are not given appropriate access to language interpretation in order to complete the process. We see this especially among Indigenous sponsors, mainly from Guatemala and Mexico, as well as sponsors from African countries. Just one example, we recently worked with a Congolese sponsor who, up to the point until we got involved in the process, had his sponsorship case terminated for no other reason than that the program had sent him the sponsorship paperwork to complete. And they said he didn't complete it in a timely fashion, even though they had sent him the paperwork in Spanish, which is a language that he didn't speak, in the slightest. And unfortunately, we see instances of that quite often. Other common challenges that sponsors run into, when their child is apprehended and placed into the custody of the ORR, oftentimes the sponsor might go weeks without even being able to get any information on where the child is, or to be able to get in touch with the child or any of the staff at the facility where the child is detained. And so oftentimes we have sponsors reach out to us who have been trying to call the Office of Refugee Resettlement hotline for weeks, only to be told, someone will reach out to you, but someone never does. And so, many of these sponsors have no real way to begin this reunification process or to communicate with their detained minor loved one without additional support in that process. Also, very unfortunately, we see a lot of reunification cases stalled because of policy violations. And so there are many instances where we work with sponsors who maybe have been denied sponsorship or receipt of a child in custody for reasons that are not in line with US government policy. We see sponsors being told that they can't receive the child because maybe they don't have the same last name or they're not the same sex as the child. And that's just not true. Those things aren't in policy. That's not in line with what is designed to help secure the swift release of children. And so in all of these instances, it really is the children who suffer. When sponsors face these barriers to reunification with this child and securing the release of the child, the children really languish in custody. And so many of them, as Maria said, are coming from already traumatic backgrounds. And then to have that compounded by additional time in ORR custody is enormously challenging. And so where we come in at VECINA to this process is that we provide reunification assistance to the sponsors. And there's not another organization in the United States doing this, but we work very specifically with the sponsor, whether they contact us directly or they're referred to us by one of our partner organizations, many of whom are our panelists today and some other attendees on this call as well. But we reach out to these sponsors and we screen them very thoroughly to figure out what it is that's happening in their case, what are the particular challenges that they are brushing up against in this process, and what is the best way for us to help them overcome those challenges. Sometimes that looks really simple. It might, just entail a phone call to help them know that they're on the right track, or to maybe help them draft a text template to send to their child's case manager to make sure they're asking the right questions or that they know what to expect next. But in other instances, the sponsor really does benefit from more individualized support and advocacy. And in those cases, we make a determination to place that sponsor's case for legal representation with one of our pro bono teams. We are very fortunate to have an incredibly dedicated army of volunteers, including attorneys and administrative support volunteers and interpreters who work alongside these sponsors. We provide them training to do this, and they work alongside these sponsors and liaise with the child's case manager and the Office of Refugee Resettlement to help shake loose these issues that have really gotten these cases stuck. And so since we've launched this project in the spring of 2021, we're just over 3 years old now. We've been able to assist with the reunification of over 1,300 detained unaccompanied children from 29 different countries speaking more than 31 different languages. And this is a broad spectrum of children and families. We've worked on cases of kids starting at 3 weeks old to children who were 1 day before their 18th birthday. So it's been a really tremendous honor to be involved in this process and to be able to support from this angle.
Molly, it's incredible that you've been able to do so much in such a short time. We've heard a bit from the lawyers on the ground, right? From the Marilias out there. We heard a little bit from VECINA. I'd love to pivot to Juliana and the Young Center now. If you could just give a quick and dirty overview of who and what the Young Center is and how important your services are. And then I'd love to hear a little bit about how family separation is impacting the children you work with.
Yeah, thanks, Derek. I will try to make it as quick as possible in explaining all the bureaucracy involved. But to answer your question, the Young Center is the only nonprofit organization that provides independent child advocates to immigrant children in federal custody. And the role of a child advocate is to fight for the best interests of children and ensure that all of the decisions pertaining to the children that we're appointed to take into consideration their best interests. And while we believe that every child should have a child advocate, our child advocate program serves the most vulnerable children in the Office of Refugee Resettlement, or ORR system. I might say ORR a lot because it's a mouthful. As an organization, we see the value and we promote a system in which every child has a child advocate and a legal service provider, helping them navigate all parts of the process, such as detention and reunification, removal proceedings, and legal relief. And while we recently increased the number of children that we have served, there are still many children that navigate this complex system without a child advocate. Our program receives all kinds of referrals, and then we have to decide where we can add value. And we prioritize which children to appoint to every month. And so this assessment includes the child's specific situation, how urgent the need for advocacy is, and our staff and volunteer capacity. We receive referrals for children who have been in custody for a long time and sometimes are struggling. Sometimes we receive referrals for children who are pregnant or parenting, sometimes for really young children, or as Molly just mentioned, a 17-year-old who is about to age out of federal custody and has nowhere to go. We also see referrals for children who have survived trafficking and so many other children who we consider as vulnerable. And so to discuss a little bit more about family separation as it relates to our work, we do receive referrals for children who have traveled here with a loved one, thinking that they would be able to live with that person. But instead, they are separated at the border, and that child is then placed in federal custody. This is something I've seen a lot in my cases over the past couple of years that I've been with the Young Center. Some sort of a family unit, maybe it's a grandparent or an aunt or a cousin traveling with a child or a young person to the United States. Maybe they raised that child and want to continue caring for them, or maybe they're the only adult left in that child's life. But if those adults or caregivers are not that child's biological parent or their legal guardian with some sort of documented proof, they are separated at the border and that child is placed in federal custody. And so this takes as you can imagine, a big toll on those children and those families. When a child advocate comes into their lives, children have often just experienced the journey to the US, leaving everything behind to then find themselves separated from their support system. They've often endured trauma in their own countries during their journeys or upon apprehension when separated, because that in itself is inherently a traumatic experience, right? So once children are placed in ORR programs, the children often don't know why they were separated, especially the really young kiddos. When they will see their caregivers again, they're detained oftentimes in congregate settings, as Maria was sharing earlier. And sometimes, the congregate settings are meant to be transitional, but sometimes children can be in custody for a really long time, which I think would be challenging for most of us to maneuver.
Juliana, when you say a really long time, let's put some numbers to it. Is a really long time 2 weeks? Is it 6 months? What do you see in your work?
I want to caveat my answer by saying that, as I mentioned, we are appointed to the most vulnerable cases, but I have had children released after 600 days in custody, so nearly 2 years. That I would say, in my own experience, is one of the highest numbers I've seen, but I in our work, I don't think it's uncommon for us to see children or be referred children that have been in custody for over 120 days, up to 6 months to a year. And, you know, these are all a lot of new experiences for really young kids to experience all at once. I hear from children themselves that they are scared or nervous about the unknown, whether that is what kind of federal program they might be moved to, or whether or not they will be able to reunify with their loved ones. And more often than not, there isn't a straightforward answer. And so children are really kept in limbo. When children are detained, they are deprived of their liberty and they are kept separate from their loved ones. ORR, as we've mentioned, is required to place them in the least restrictive setting according to policy, and also release them in a timely manner to their sponsors. While in custody, children are kept away from their support systems and most often their culture and customs. ORR tries to meet the needs of those children. And we also have to recognize that it's a really tall order, especially when there's so many children of so many different backgrounds in a congregate setting. It's a big challenge. And I also think that separating families takes a toll on those relationships. I think it's really stressful for both the child and the adults. If we think back to our own childhoods, most kids operate on the assumption that the world revolves around them, right? You meet a little kid, like everything is about them. And this egocentrism is a normal stage of development. And so when you're separated from your loved one and your trusted adult is trying so hard to meet these sponsorship requirements, but the complex process creates delays, and you also get a set amount of time to speak with them on the phone per week to really connect, you might start to think, you know, do they really want me? You might feel angry or sad that they're not meeting those requirements. And there are a lot of emotions that come up. It's a really hard situation, I think, both for the children and the adults. I've seen relationships get strained over the course of a really long time in custody, and it's not because families don't love each other or don't want to be together, but I think it stems from a lack of connection, and maybe it's a sort of defense mechanism. There's a lot of research on the negative effects of being separated from your family, on the negative effects of detention itself, and the lasting psychological impact on the whole family. In my experience, the family separation cases I worked on are often correlated with a longer detention in custody because there might not be another person available to sponsor that child. And so in effect, a young person is separated from their loved ones for a very long time, and the child remains in custody. When those two variables are there, the worse the negative effects become.
I think, unfortunately, that makes sense. You know, one of the Young Center's guiding principles you mentioned is the best interest of the child, right? And based on what you're saying, I'm assuming that best interest often involves advocating for the swift reunification of a child with a family member. You know, when you're doing that work, when you're pushing the government to reunify a child swiftly, what are some of the barriers that you commonly see in the reunification process?
Yeah. So what we mentioned, you know, the OR does have a set of policies requirements for sponsors, but at the same time, not every case is the same in terms of what might or will be required. And sometimes even over the course of a case that those requirements might change. So if a child is considered particularly vulnerable under federal law, there's even more of a magnifying glass on that sponsorship. But something we often see is when a loved one, an adult who has recently arrived in the United States, tries to go through the sponsorship process to reunite with the child, they're confronted with all of these requirements, right? And, you know, so I assume a lot of us here might be immigrants or know and love an immigrant. And you know that when you come here, families who have just entered the United States with nothing but what they carried may have a hard time meeting some of those sponsorship requirements, some of those thresholds that are required by policy. And sometimes those turn into barriers. Similarly, families who are already in the US may still be adjusting to their lives here. They may have limited resources or are working just to survive day by day. But neither of those experiences mean that they can't care for their child or that they shouldn't be together. Sometimes sponsors withdraw from the process to get better situated, especially if they've recently arrived, or maybe in transition, with the hopes of being able to try again later. But sometimes a sponsor is denied by ORR, and depending on the type of relationship with that they have with the child, the sponsor might not be able to appeal a denial. This happens mainly for sponsors who cannot prove an immediate relationship to the child. So think like a second cousin or a more distant uncle or even a really close family friend. Children may have different definitions of family that may not align with the categorization attributed by the US government. And those who don't meet traditional definition of family as outlined by the US government are often prohibited from appealing a denial. Another barrier I've seen is that, of course, there's a human element. We're all human, and we all have different biases and experiences that inform our interactions with others. And yes, there are policies written down, and they're also interpreted by people. And sometimes interpretations vary, and different decision makers might make different choices. But a denied sponsor might subsequently be barred from trying again at a later time. So even if a different interpretation is offered, it might be too late for that sponsorship. And at the Young Center, we advocate for decision makers to make trauma-informed decisions and be culturally sensitive, right? And take into account the child's best interest. But oftentimes overcoming a denial is really, really difficult. And those types of cases require extensive advocacy. And the Young Center partners with VECINA and Molly's team. And these are some of the cases that we have often collaborated on.
Thanks so much, Leona. Hi, Nicole, how are you? I'd love to get a little bit more historical context for the things we're talking about today. It's great we have you here because you're the one doing the work at the border with families who are seeking asylum. What trends have you seen, recently and more historically going back to around 2015 with respect to separation of migrant children from their family members? And how have you and Otro Lado responded to these issues?
Yeah, thanks for having me today, Derek. In 2015, which was the Obama years, which some advocates still romanticize, although fewer and fewer, we were talking with families about the prospect of separation in the context of two-parent families coming to the border and separating dad from the rest of the family and putting him in a detention center potentially thousands of miles away, where he may never see his family and his children ever again before being deported, as well as talking with family members that were unaccompanied children, like the children we're talking about today, about the prospect of them being separated from the caregivers with whom they traveled to the border. Coming through 2017 and 2018, as we saw these large caravans of asylum seekers from Central America arriving at the border, we started to hear rumors that the administration would be testing out, piloting a family separation policy, taking children from their parents. And because we had seen what they had done with two-parent families in the past, we were working with asylum seekers around the idea of self-separation before they entered custody. So one parent entering with one child and the other parent entering with any other children that the family might have, and separating on the Mexico side of the border with the hopes that each half of the family would clear the immigration detention process and could reunite more quickly on the US side of the border, which, as a lawyer trying to explain strategies and rights to asylum seekers, that's just a place that none of us imagine that we will ever be, trying to outsmart the government that allegedly stands for the protection of human rights in order for them to protect their human rights and the sanctity and integrity of their family. We did see in the advent of the May 2018 caravan, the zero tolerance policy become a border-wide policy in which children were ripped from their parents' arms, both children where they entered the border without inspection. I'm not going to say illegally, because we're just going to begin with the premise that the border itself is illegal, as well as those families that did it the right way and went to the port of entry to try to present themselves. It didn't matter how they did it. The policy was deterrence through inflicting the maximum amount of pain, and the maximum amount of pain in many cases for many people is family separation. In the aftermath of the family separation crisis, and after the federal court ordered an end to the zero tolerance policy, we were still encountering more isolated, but still incidents of family separation of children being taken from their parents. And specifically in the case of US citizen children being taken from their immigrant parents upon being processed at the port of entry. And the excuse that border authorities would use is that US citizens can't be detained in US immigration custody because they're not immigrants, they're citizens. Now, the agency has the discretion and the authority to release those immigrant parents with their US citizen children. But again, to inflict the maximum amount of pain as a deterrent, they chose to rip those children from their parents' arms and place them in the state foster care system rather than give that family a conditional release from the port of entry and a notice to appear in court at a future time. We have also seen during that time the aftermath of MPP and Title 42, the attempts of border authorities to retain babies in the US of migrant moms that have crossed over while perhaps in labor or gone into labor while they're being processed, and send mom back to Mexico while those US citizen, US born babies were retained in the US. And that's another family separation pattern that's not really spoken about.
Nicole, can I just ask you to clarify for the audience what MPP is and what Title
I'm
42
so
is
sorry.
as well? No.
MPP was a now defunct program known as the Migrant Protection Protocols, which forced asylum seekers to wait out their entire court process in Mexico with periodic entries into the US for their court hearings. Us on the ground referred to it as the Migrant Persecution Protocols because that felt a little bit more accurate as to what was happening. In the aftermath of the supposed end of the zero tolerance policy, Otro Lado was working with asylum seeking parents on creating these declarations that they would carry on them before entering custody, in which they would state unequivocally, my name is such and such, I am such, this is my child, and I do not consent to be separated from my child under any circumstances, because a lot of times border authorities had previously used the fact that they had obtained consent to separation from the parent. But really, that was not a voluntary consent when the options were, well, we can deport both of you back to Honduras or Guatemala, or your child can have the chance to potentially find safety from violence and freedom in the US. And that's not really a voluntary choice. We also, in the aftermath of the zero tolerance policy, we're working with families at the port of entry before they were entering. And we had, Sharpie permanent markers helping families write the names of their children on their arms and write their names on their children's upper arms. Because as we know from the family separation crisis, CBP did not do any kind of job. I won't even say a terrible job. They did nothing to keep track of a lot of these children. And some of these children are never going to be reunited with their parents again because they were nonverbal when they were taken. And so to avoid that, we were helping families to write the names of their children on their bodies in case they were separated and records were not properly kept, which again is another horrible place to be in as an attorney working within a legal system, but doing tactics that really are anti-fascist.
That's horrifying, Nicole. Can we talk a little bit about what you're seeing now in this post-zero tolerance moment? Children are still being separated from, their non-parental family members. And how do you fill that gap when, the services you provide aren't sufficient?
So we do the accompaniment piece on the Mexico side. We walk the children directly up to the pedestrian walkway, the gate where CBP is processing documents, and we demand that they let them in as unaccompanied minors, but we don't have the capacity because we're at the border to work with the families once the children have been sent to a migrant shelter for unaccompanied children on the interior. And the documents that are part of the reunification process are not necessarily intuitive, even if you are an English language speaker. And the families need help navigating that process and working within the bureaucracy, which is also going to include caseworkers and perhaps other professionals that are part of the system that is making decisions about these families. And VECINA really fills that gap for us because regardless of the language that child speaks, which also can be a barrier to a quick quicker reunification, VECINA is receiving these families and working with them step by step through the process in order to shorten that period of separation to as short as we can possibly make it. And you know, as VECINA has increased its capacity, they've also been able to, you know, work with more families, but also work with families more immediately. So as soon as the children are in custody, you know, they can be working with the families on their paperwork to shorten that separation process.
Thanks, Nicole. Let's fast forward to present day right now. You know, are there any instances in which the US government is not separating children from their non-parental caregivers, or is it there's sort of a blanket rule here?
We saw when we had this large influx of Ukrainians fleeing the outbreak of war with Russia come to the border, and there was a lot of outcry around a few stories of Ukrainian children being separated from their non-parental caregivers who had, you know, cared for them throughout the whole journey, maybe out throughout their whole lives. And that immigrant community really mobilized in the United States, really leveraged its political connections. And the Office of Refugee Resettlement, which is the office that makes decisions around reunification for at least the time that we were receiving that many Ukrainians, it had a point person in the San Ysidro Port of Entry making those on-the-spot determinations as to whether this family should stay unified or should be separated. And so we saw a lot less separations of these families. And we have yet to achieve that same result with any Black or Brown family. So part of it is, you know, that community on the US side has a lot of more inroads into helpful politicians. And the other part of it is, you know, white supremacy, and they have the privilege of whiteness that gets them through decisions that Black and Brown immigrants will spend, you know, days, weeks, months, and years trying to overcome.
So what you're saying is it's possible. There's another way than what's been happening here.
Oh, it's absolutely possible. But you know, it's a decision that's in line with all of the decisions of the agencies processing asylum seekers at the border.
Thanks, Nicole. Molly, sticking with the theme of, you know, Russia's invasion of Ukraine, Ukrainians aren't the only people fleeing that conflict. There are some Russian families as well who have presented themselves at the border. I'm wondering if you could address a little bit, Molly, the current issue of separation of Russian families at the southern border with Mexico.
Thanks, Derek. And just piggybacking off of what Nicole just shared, I just really want to highlight what Nicole said of, you know, there are ways to prevent family separation. We've seen it happen with Ukrainian families where there's a will, there's a way. There are mechanisms to do it when we want to. And there are also mechanisms to make family separation happen when we want to. And so looking at that, I want to highlight a current trend that we have seen in our project, which is the separation of Russian children from their biological parents at the border, despite this being an unlawful practice. These are the proven biological parents of the children. They have all the documentation to prove as much when they present themselves at the border and are apprehended. What we have seen in the cases that we have worked on of separated Russian families is that they have been separated for no reason other than their nationality and the fact that, according to the US government, they present some kind of national security concern based on their nationality. In the families we've worked with, you know, some of the families have been supporters of Ukraine, which is actually the reason that they fled Russia in the first place. But what we have seen in these cases is, you know, the separation happening at the border, the children being sent to ORR custody, and the parents subsequently being sent to ICE custody. And so in these cases, we actually have our hands tied in a way where, you know, in some of these other cases where we might be able to work on a reunification case to reunite children with their parents are still in custody. And so we can't pursue that reunification case. And so, you know, thankfully in these cases that we've encountered, there have been family friends in the United States who have come forward and stepped up to sponsor these children. And so we have assisted in the reunification process of those children to reunite with these family friends, while very sadly and unnecessarily, their parents remain in ICE custody. And so I think this issue really highlights how geopolitical tensions, the United States' currently very tense relationship with Russia, can really exacerbate the already very challenging issue of family separation and really compound the trauma that these families have already experienced by then going and separating them. And so really just kind of going back to that point of there are ways to not separate families. And we put in place the mechanisms to avoid doing that when we decide to. And then we also put in place mechanisms to forcefully separate families when we decide to. It really is a matter of there being, where there's a will, there's a way.
For sure. I'm so glad that VECINA's Reunite program is there, trying at least to minimize as much as possible those effects. Is there anyone else in the United States, any other organizations that are offering this type of reunification assistance to potential sponsors?
There aren't. So VECINA's Reunite project is the only program in the United States that offers pro bono reunification assistance specifically from the angle of the sponsor. There are many, many wonderful organizations that are legal service providers for the detained children. My panelists here from KIND, Marilia works for one of them. There are many organizations that provide advocacy for detained children. Juliana is one of them. All of these organizations receive federal funding to provide this support from the angle of the child, and it's so important. But what is lacking is funding to support reunification from the angle of the sponsor. There's no federal funding to support reunification from the legal angle of the sponsor. And so as the only organization doing this, and in this particularly critical and challenging political climate that we're in light of the upcoming election and the uncertainty surrounding the upcoming election, and the fact that there really isn't, a candidate right now who's particularly pro-immigrant at this point, securing funding in order to sustain this project is incredibly challenging right now. And we are very hopeful that this is going to turn around, but in order to urgently secure the funding we need to push this project forward and continue reuniting these families, we're actually launching a Reunite fundraising campaign through the end of this year with a fundraising goal of $75,000. And this is so critical for us to be able to continue partnering with our partners on these calls who refer these cases to us, and to be able to support sponsors who reach out to us directly. If we can't secure the funding needed to continue this project, VECINA is going to end up in this position where we have to make really difficult decisions about whether we can continue this project. And if that happens, if this project discontinues, as it currently stands, there will be no other organization for sponsors to turn to in the reunification process. And kind of reflecting on, the hundreds, thousands of cases we've worked on at this point, and just knowing how incredibly stuck some of these cases were, we know that this is a problem that's going to continue very sadly, and that there are going to be sponsors who desperately need this help, and that reunifications in many cases won't happen unless that sponsor has this support. I know some of my co-panelists have already highlighted this, that, in some of the more vulnerable instances, children spend, many months, often a year in custody. We've worked on cases of children who've spent more than 2 years in custody. I've spent many years working with children directly in ORR custody. The longest length of stay I've ever encountered of a child I've worked with is just shy of 7 years. And so it happens. And I know that in some of these instances, the support for the sponsor is what makes the difference between a child staying in custody and a child being released. And so, looking at families who've been separated at the border and the ability to help reunite them and bring them back together. And then also families where maybe they haven't been separated at the border, but they're being kept separate unnecessarily. Children who are languishing in custody when they have someone here who's ready and willing and able to receive them. They just lack the support in the process. And so with the launch of our Reunite fundraising campaign, we're hopeful that we're going to be able to continue this work into the future. And I really want to take the opportunity to acknowledge one of our incredible partners. I know we have some of them in attendance on this call today, just to express our gratitude to the Walt Disney Company, who has kicked off this fundraising campaign with a very generous $10,000 donation. Not only have they donated to this campaign, but they've been very generous in their volunteer support for this project to help reunite families. So my call to anyone in attendance today is, if you are in a position to support these efforts in any way, or if you know anyone who is in a position, we just ask you from the bottom of our hearts to help spread the word. I'm going to be dropping a link in the chat to our fundraising campaign, and I'll be sharing my email address there as well. So anyone with any questions, please feel free to reach out.
Molly, thank you so much. I think what your co-panelists really highlighted today is the need to support all people involved in this process. We have KIND, the Young Center, Otro Lado, whose work focuses either before crossing into the United States or exclusively on the children after entry, which is great and wonderful that we have all those services. And we also need to support the adult family members and other loved ones who can welcome children into their homes, help them recover from the trauma of these difficult journeys, and live safely in the United States. So Molly, thank you so much to you and VECINA. Encourage everyone in the audience today to consider donating to this fundraising campaign. I want to thank Liana, Marilia, and Nicole for taking time to share their experiences, expertise, and thoughts today. And thank you everyone so much for joining us.
Thank you all so much.
Hope you all have a good afternoon. Take care.